a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
It's time to hand out some expert but some free legal advice this morning. David Whiting is back with you, and you can join us as well. 1300 222 774 if you'd like some advice this morning. David, good morning to you.
Good morning, Virginia.
Nice to talk to you again. How's your time been in the last week or so?
Well, pretty much like each of the previous 15 or 16 weeks. No huge differences. We can now walk a little bit further than we used to be able to.
Yes,
so,
well, there's at least that.
Yes.
Was there any homework we needed to clear up from last week?
Well, Michael from Coburg rang last week, and he's got a VCAT order and he wants to enforce it. And he was having all sorts of difficulty because he was taking the order to the magistrate's court and saying, no, I want to register it. And the system has changed, and what you now do is you email VCAT with the case reference number and the date of the order, and VCAT then tells the court. The court then tells you that they've got the order and you can then enforce it. But if it's a monetary order for $100,000 or less, it's the magistrate's court. If it's more than $100,000, it's the county court. And if it's a non-monetary order, it's the Supreme Court. Now, the catch is that quite often you'll get an order at VCAT that somebody do something, not pay money, but do something, fix the kitchen cupboards, whatever it is. Yeah. That's a Supreme Court enforcement application.
Oh, God.
Yes, all of a sudden it's become cheaper to fix it yourself rather than line up.
Just walk away from the problem.
But VCAT then offers a solution to that. And if you have those kinds of issues, you can go back to VCAT and have the matter reopened and ask for the money instead of the box.
Okay.
So there is light at the end of the tunnel. It's a long tunnel and the light is dim, but it's there.
You can see the light.
Yes.
Many of us non-legal types often can't.
No.
David Whiting is here with you to offer you some advice. 1300 222 774. I've got a couple of lines free, so grab them because they go fast. Harry in Mount Waverley is first this morning. Good morning, Harry.
Good morning.
Go ahead.
Yeah. Thanks for taking my call. We signed up to buy a property. The property was advertised with an al fresco. The contract was subject to building inspection and finance approval. So we got the building inspected for any structural damage or defect, and they said it's structurally okay. And the finance was approved, and the contract became unconditional.
Yes.
But since then, we got the council to check whether the al fresco is formalized or whether they have taken a permit. And we asked the vendor solicitors whether the al fresco has been given a permit, and they said it was like-for-like replacement, and they informed the council about it. But then the council said, no, it is unauthorized structure, and they issued a building notice. Now, what can we do and apparently they are not going to do anything.
There's under the standard form contract that you signed, Harry, compliance with notices issued after the contract is signed, the responsibility of the purchaser. So the demolition notice that you got from council is technically your issue. What I would suggest you do is get your lawyer or conveyancer to look at Section 12 of the Sale of Land Act, which makes it an offence to provide information, knowingly concealing any material facts. The other thing that you should do is there are a couple of products around that take aerial photographs over a period of time.
Yes.
So you should be able to go back and look at aerial photographs and see if there has been a construction there that might not require a permit.
Yeah, the vendor solicitor said it was like-for-like replacement. But
I understand that, but that doesn't make the council notice go away.
Yeah.
So I'm suggesting that you use Section 12 of the Sale of Land Act to put some pressure on the seller to fix the problem, because the penalties are quite high. But then what you want to do is find someone, perhaps talk to a surveyor about whether you can have access to their aerial photographs so you can see what construction has been there over the last 10 or more years.
Okay. Good luck with that, Harry. That sounds like an alarming situation. It's a shame the council came in and saw it in the first place, I guess. David?
Well, it's one of the issues that you get on acting on either the sale or a purchase of a property as to precisely what research you should do. Now, in England they do what they call building surveys. So somebody goes over the property from top to bottom before you buy. In New South Wales, we get termite reports that we tend not to get here. So it's in Victoria, it's actually quite. It's not rare, but it's not common to get a building inspection report. Although I would have thought far more advisable, and also to find out what permits are being granted in relation to the property. It's more a question of everybody wants to do it as cheaply as possible, except the people who have done it as cheaply as possible and missed out on something.
Yeah, absolutely. Let's hear from Cliff in Druin. What's going on, Cliff?
Oh, look, I'm going to jump right to the end. I have a natural spring at the point of my block, and my block is roughly an isosceles triangle. It's a hammerhead block, and this natural spring has a water surface that flows onto the property's both sides, which has one side runs a few head of cattle, and it's drinking water for those cattle, and the other side had a herd of cattle, and it was drinking water for them up until 6 months ago when they disappeared. That site is about 40 acres, and I've just learned that there's 140-something homes going to be built there, and I've tried to establish whether or not they're going to be building over the top of the spring, well, not the spring, but the water from the spring, and the answer was yes. And I said, well, what happens to the spring? And they said, well, we're going to drain that. And I'm wondering whether they can drain a natural spring, how they do that, and if the spring is on my property, as I'm assured that it is, then do they need access to my property to drain it?
Well, no, because they could drain it downstream of your property. But you had me stuck at the beginning, Cliff, because you described your block as an isosceles triangle and a hammerhead, and it just, the geometry of had me confused.
Okay.
Worry not. Look, the issue is the Water Act. They are not supposed to interfere with the natural flow of water. I would be talking to the council about the spring or the soak and how the water normally discharges and what's going to happen. Because if they were to dam it in some way so that the water blows back on your property or flows back onto your property, then they will be committing an offence under the Water Act.
David, I have spoken to council and who have been very less than helpful, and they just said the answer was, well, it'll be engineered properly, and that was the end of it. That was all they had to say. And then they sent me some forms to fill in to require any other information that I wanted with a payment of $155 by credit card to receive it. And it's not what I wanted. I don't want to see permit plans and so on. I just want to know whether or not the spring, which some degree of labour has gone into landscaping and planting around it and rockery and so on, and it's covered with water lilies. It is a haven for hundreds of frogs, and it draws a fair bit of bird life. I have ibises.
Sorry, Cliff, are we talking about works on their property or your property?
Well, the spring is on my property, but the water from the spring flows onto the development site and the neighbour the other side.
I understand that, but they own the property. They're the people who make the primary decisions about what happens to it. It's the developer's land, and the developer has the principal choice about what happens to the land. Now,
Yes.
If you want to maintain the aesthetics of the area, it's like saying, you can't build that house next door to mine because I don't like it.
Right.
So I would be talking to the developer perhaps to find out how they are proposing to deal with it, because your issue is not that the water be drained, but you actually want it to stay.
Yes, I do. Yeah.
Yes. That's like saying I've got to manage my property the way you like because you live next door. So there might be an environmental matter that you might bring to the attention of council to review any permits they've got. There might be an environmental overlay that needs to be addressed. So I would ask the council for a copy of the planning permit that they've received for the development, and then get someone to look and see whether everything that needed to be done according to the overlays that affect the property have in fact been done. I mean, I was involved in a property north of Melbourne for a client where there were frog issues on the creeks. So you just don't know what's there. You've got to go and find it.
Right.
Good luck.
Thank you, David. Thank you very much.
No worries. Thanks so much. At Fukuo is called in from Ormond. Good morning.
Good morning. Good morning, Virginia and David. I'm actually calling on behalf of my friend. She's a really nice friend, and she lent money to her former brother-in-law, who was a director of a property development company a few years ago. And his company has gone into administration, and somehow she has been pursued by his company's liquidator, even though she was just a debtor. So I was just hoping David can clarify how she ended up in this situation.
You may be confusing debtor and creditor, Fukuo. If she was a debtor, then she owed the company money.
Yeah, sorry, yes. I'm not very good with legal.
That's okay. That's all right. I always got stuck with mortgagee and mortgagor, but we'll keep moving. Fukuo, what I suggest you do, the company will have filed a statement of affairs, and it may well be that your friend's money is simply on the right side of the ledger, on the wrong side of the ledger. But what your friend wants to tell the liquidator is that I have never borrowed any money from this company. They may have made some book entries which would indicate otherwise. Did your friend get paid back by the brother-in-law from company money?
Yes, so she lent 3 times. First 2 times she was paid back, but the third one she's still waiting. So that happened last April, and her brother-in-law has been living overseas, so she can't chase him, and she's sent him most of the emails.
Fukuo, you've changed the problem. It's no longer the money that was lent to the brother-in-law. It was the fact that the money which has come back to your friend came from the company in liquidation. Right. So it would be like you lending money to Virginia and I paying it back, and then I go bankrupt and my trustee in bankruptcy says, you've got some money, Fukuo, that you're not entitled to, give it back to me, please. So I'll take, homework's a bit quiet at the moment, Fukuo, so I'll take it on notice for next week.
Yeah, if you would, because I was utterly confused by that. So
Yep.
Yes, okay. I'm a bit confused.
I'm totally confused, so but please take that one.
The issue is that the money was paid back by the company. So the brother-in-law used company money to pay a Fukuo's friend.
Yes.
And does that mean she has to give it back?
Yes, absolutely. Okay. We'll dig into it. So, Fukuo, please tune in next week, have a listen, and David should have an explanation and maybe even some advice for you because of that. Eric in Ringwood, what's happening in your world?
Yeah, good morning. Another council problem. 30 years battling with the Maroondah Council over an illegally occupied lane. The people who are occupying the lane have trees growing in the lane that have pushed the fence over, and now the council says we should reinstate the fence that the illegal occupiers have had knocked over with their trees. Now, what do you do?
Well, you can't get the council to contribute to the cost of your fence. Have the other people fenced it in with their property?
Yes. But it is classed as an illegal occupation by the council.
Yes, so what are they proposing to do about it?
Nothing. We've been battling with them for 30 years, and they now say when they get the time and when they get the funds, the council, they will address the matter. This is the second time in 2 years that they've given us that answer. They'll look into it if they've got the time within 2 years.
Eric, I'm mildly lost. How is it that council even came to you and told you you needed to fix the fence?
The council haven't told us. We would like to fix the fence because the fence has now been knocked over. But
yes.
We've been told we should pay for the damage caused by the illegal occupiers. So their trees have knocked over the fence, the illegal occupiers, and we've been asked to reinstate we've been told that we should pay to have the fence reinstated.
Oh, you want the fence, and the council says, well, we're not paying.
Yeah, and the illegal occupiers won't pay.
Can I just jump in there? What do you mean by illegal occupiers? Who's been in the lane and what have they been doing?
Okay, the term used by the council is illegal occupiers.
Yes.
So they've fenced off the lane, the people at the back, and according to the council, they are illegally occupying the lane.
So they've fenced off the lane and they're using it as part of their property on the back.
Yep.
But Virginia, 15 years ago or more, you used to be able to get adverse possession against councils for lanes. You can't anymore. So if you hadn't commenced an adverse possession claim by the time the legislation came in, you simply lost the ability. So the laneway behind Eric's property will still be council land, will always be council land until they sell it. But there's somebody using it.
Sure. No, I just wanted to know if there was a great description of, some property that had been set up there or some structure that had been built and the like. These stories are always intriguing to me about what people get up to in lanes. All right, so what happens here, David?
Well, Eric's between a rock and a hard place. Well, you could ask council if you could go and cut the trees down. But that would just simply create... Well, first of all, it's going to cost money and it's going to create a problem with your neighbour. My belief, Eric, is that you have the right, because they are in occupation of the land, you should be able to commence a defences action against them.
Yeah. Can we offer to buy the land from the council?
You can.
Yeah. But do you think 30 years is a little bit long to be waiting for the council to do something? And as of 2 weeks ago, they've said within the next 2 years, they may have a look at it.
Eric, I think if we opened the phone lines on that question, there would be a significant number of callers.
Okay, Dave.
Well, sorry about that. But I know that the shenanigans in laneways around Melbourne, David, over the years have been, really complex. And there are those who sort of missed the cut in trying to get access to that very valuable strip of land out the back.
Oh, yeah, and now council wants, $10,000 a square metre type stuff.
Wow, amazing. Okay. John in Dalesford, morning.
Morning.
Hi, go ahead.
You got the tissues ready? You might be in tears after this. Look, I approached a solicitor early this year before COVID got going. I wanted to act on a civil matter for me, and she took $450 the first meeting I had with her. She then told me it would be another $1,550 later on to carry the case on. Then COVID came into play. It was put off until December. I then went to see her again just to have a chat about it.
Yeah.
About the matter. Her office is in her home. She opened the door a fraction, said to me, "Stop harassing me." So I thought, okay. So I left. Since then, she won't answer my phone calls, emails, text messages, you name it. I'm just wondering how I might be able to recover me $1,500. Who should I go to?
If you think that if you've got a dispute over the value that you receive for the money that you paid, you can take the matter up with the Legal Services Commissioner.
I've sent them a huge email.
Yes.
And I've never had an answer.
Can I say I'm very surprised? They are normally on the phone very quickly.
Are they? Well,
yes.
I might give them another chance to say, look, I think I could kiss the $1,500 goodbye, but I just thought you might. But I'll give that I'll give them another try if you think that's the way to go.
Well, you don't want to hire another solicitor to have a go at the first one, because that would be putting.
No, I don't want to do that. No,
that would be good money after bad.
Yeah, of course.
Yes.
And I think in this COVID, I've thrown a fair bit of money away.
Look, it's possible to go to VCAT. It's possible to go to the Legal Services Commissioner. I would go there because they run what amounts to an effective small claims jurisdiction. But the difficulty that lots of people have with lawyers is that there's a difference. While you're buying their skills, you pay generally on the time it takes to provide them.
Yeah.
You know, so what you purchase and how you pay for it are just so different.
Yeah. Fine. Okay.
Good luck.
Thanks for the info.
Thanks so much. Tony in Elstonwick is up next. Good morning.
Hey, good morning, David. I've got a question. Recently, I've been subject to a tax order, and I'll go back to one of my early MasterCard statements, and I found an unauthorised transaction from Emirates Airlines and $4,290 going back to 2009. They rejected that. Then I went to Westpac, and they said no. Where do I go from here? My first inclination was to go to Australia, given those fines.
Sorry, Tony, we have a general principle that we try not to name people because we don't give them the opportunity of responding.
Yeah.
So we're talking about an airline 11 years ago.
Yes, correct.
Right? Okay. The answer would be, you have nowhere to go. There's this piece of legislation called the Limitation of Actions Act.
Correct.
And it says, look, if you've got a claim, you've got to bring it within a certain period of time or otherwise you lose it. Correct. Now, if you haven't checked your credit card statement for 11 years, I'm not sure that a lot of people will have sympathy.
Okay, but my question is to you then, given that Austrac has fined the Westpac $1.3 billion, do you think you can put $4,290 on the end of it?
Probably they don't have enough change.
Yeah, and you're sure this wasn't a transaction that was done by you or that you did on behalf of somebody else?
Never travelled overseas.
And didn't buy a ticket for anybody else?
Or anybody else, nothing at all.
Sorry about that then, Tony. That seems to be the end of that. I think we do, if we're quick, maybe, Maggie, we can get to your problem. Are you able to be quick, Maggie, or should we wait for next week?
I'll try to be very quick.
Uh-huh.
Back in the 80s, my brother-in-law was at university and the state trustees came around. He made a will, but after he graduated, he was struck down by a serious autoimmune condition.
Mm-hmm.
He's been in supported accommodation for decades, and it means his estate is all cash, and we don't see, and the beneficiaries are my husband and his sister.
Maggie, is he able to make a new will?
No, his brain is very damaged. That's the problem. That's the problem. How do we get shot of the state trustees who will charge a ridiculous fee for nothing, really?
Well, it will be a simple administration, is what you're suggesting. Yep. There is a possibility to make, and do we know what his will says?
Yes. We've got a copy of it. The trustees.
So it's going to the right people. The only issue.
No, it's not. For instance, the will was made as if he was going to die the next day. Our son, his nephew, was willed his computer. Well, of course, that is long gone, and there's no mention of
Maggie, there is a process for making what's called a statutory will, and an application is made to court for a replacement will. The issue, from my point of view, would be whether the estate is likely to be large enough to pay for the costs of the application. But it's an application made to the Supreme Court for a statutory will.
Supreme Court.
Yes, all right. And you don't see them made very often, but you do see them made a few times a year where it might be a really old will that is so far out of whack, and there is a way of knowing what the person wants.
Is there a way of knowing what he would really want?
Well, yeah. Now he has got... there's our son, his nephew and partner and his children. There's no further mention of them apart from that computer. So, of course, the family has grown with these extra children. So,
Maggie, stop there, right?
Well, yeah.
What we're doing is we're proposing to make a statutory will because the will is wrong, right? And not because we could make a better one.
Mm-hmm.
It's not a question of, so it's not your will with his name on it. It's his will with his name on it.
Yeah.
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 Now that was my question about, do we know what he really wants? And it's not about imagining what you might want or think. So I guess that's the challenge there, David. How do you establish that even if you get a statutory will?
Well, that's why they don't like doing statutory wills, but they do them because it's, how do I really know what this person wants to achieve?
Indeed.
Yeah.
Mm. All right. Well, I guess you'll need to make that assessment out whether the value, as David says, the value of the estate is actually worth the cost of doing it.
Well, it's about $500,000 now and growing because my husband's been very careful about how he's invested his money, his brother's money.
Well,
so
we'll leave you to make that assessment, Maggie. Thanks for calling in. I hope that was useful. David, got a bit of homework there. Thanks for that.
Thank you.
David Whiting, Melbourne solicitor.